Hi, today we will be doing polity and constitution. Today we will be doing 50 questions. So without wasting time, let's move on. The first question here asks, consider the following statements about Rajya Sabha. First statement says that it can pass a resolution authorizing Parliament to legislate on a state subject. Yes, that's right. It can pass a resolution authorizing the creation of new All India Services. Article 312. It can amend money bill passed by Lok Sabha. So we know that money bill can be only introduced in Lok Sabha and it can be amended by Lok Sabha only, and the Rajya Sabha can just give some kind of advices. So it is wrong. Then a no confidence motion against the government can be moved in Rajya Sabha, which is definitely wrong. So we arrive at option 2. Yes, it is right. Let's move on to question number 2. Question number 2 says that the statement 1 says that the scope of personal liberty under Article 21 has expanded enormously since 1978. Yes, that's true. In Menka Gandhi, the Supreme Court held that procedure depriving a person of liberty must be just, fair, and reasonable. Yes, that's right. Maneka Gandhi established the Golden Triangle of 1499-21. Yes, of 1499-21, which is absolutely right. So we arrive at option A. Let's check it. Yes, it's right. Let's move on to question 3. In Association of Democratic Reforms versus Union of India, the Supreme Court struck down electoral bond scheme primarily on the grounds of violating. So we usually know that it violated a citizen's right of RTI, right to information. So it should be option 1. Yes, that's right. Let's move on to question number 4. Here they have given the 4 cases. They are asking how many are actually right. Bureau Union case, where the principle is preamble is not the part of constitution. That's right. Keshavananda Bharati case, preamble is a part and can be amended. Yes, basically this case gave us a basic structure doctrine where it allowed certain parts to be amended, whereas it restrained the executive from amending some basic features. That's correct. Both are correct. Golaknath, Parliament can amend fundamental rights. Here they are given exactly opposite of it, because here the Supreme Court said that Parliament cannot amend fundamental rights. So that's absolutely wrong. In Menka Gandhi case, article requires no fairness and procedure. Again, it is reversed. So these both are wrong. We arrive at option 2. Yes, that's right. Now let's move on to question number 5. A governor cannot keep a bill passed by state legislature pending indefinitely. Okay. Indefinitely, because the governor doesn't have pocket veto as of the President of India. In 2025 advisory opinion under Article 143, a constitutional bench held that concept of courts granting deems assent to the bills has no basis in constitution. It's right. So basically, it's a statement and we have to answer based upon these 2 statements. Oh, this was the reference statement. Okay. The same opinion held that prolonged unexplained inaction by the governor on a bill is amenable to judicial review. Yeah, while both of these are correct, but I don't think this will any way explain this, because this is the only perfect explanation for this question. So it should be option B. That's right. Let's move on to question number 6. Article 15 prohibits discrimination by state as well as by private individuals on grounds of religion, caste, sex, and place of birth. While 15 clause 1 does it for state, 15 clause 2 does it for private citizens. As they have not specifically asked for 15 clause 1 or 15 clause 2, I think we should apply it basically only for the state. So option 1 becomes wrong. Article 16 guarantees equality of opportunities in public government to citizens as well as foreigners. No, it's wrong, because it's only applicable to citizens. If we can remember here, Article 15, 16, 19, 29 and 30. These 5 articles are exclusively available only for the citizens and they are not available for the foreigners. Okay, let's check it. It's correct. Let's move on to question number 7. Indian Penal Code 1860 replaced by Bharatiya Nyaya Sanhita. Okay, that's right. Code of Criminal Procedure, CRPC, Bharatiya Nagarika Suraksha Samhita. That's right. Indian Evidence Act, Bharatiya Saksha Adhiniyam. That's correct. Information Technology Act replaced by Bharatiya Saksha Adhiniyam. No, it's actually wrong because it is not replaced by this act. So this is wrong. 1, 2, 3 are right. We arrive at option 3. That's right. Now let's move on to question number 8. Yeah, it's a question is based on the majority required, basically the amendments and the procedure involving in it. First one says creation of new state, simple majority, no state ratification. That's correct because Parliament has absolute power to create or destroy or to rearrange, to change the names of the the states under Article 2 and 3. Now second is the election of the president, special majority, yes. State ratification required, yes, because it will affect the federal nature of Indian polity as well as it will affect the core basic features of the Indian constitution. So it needs special majority as well as state ratification. Both are right. Next, fundamental rights, special majority, state ratification. No, I don't think it does need the state ratification. The fourth one says that distribution of power, special majority, yes. These 3 are right, but this one is wrong. So we arrive at option 3. That's right. Now let's move on to question number 9. A resolution for removal of vice president can only be initiated in Rajya Sabha. That's right. Only the elected members of both houses participate in the election of the vice president. No, it's wrong. But yeah, it's absolutely wrong. So we're at option A. Let's move on to question number 10. Here they are given some offices and the one who appoints them, and they are also given the constitutional articles. So first one is Prime Minister, appointed by President. We all know that under Article 75. Yes, that's right. Attorney General by President, Article 76. It's right. CAG, Prime Minister, and Article 148. Although Article 148 is wrong, but he or she is not appointed by Prime Minister. It is done by the President. So it's wrong. Chief Election Commissioner by President under Article 324. Absolutely. 1, 2, 3 are right. So we are at option C. Let's move on to question number 11. Under Article 13, a law that violates fundamental right. So basically you are asking about the law, what will be the condition of the law if it violates fundamental rights. First option says that remains valid until Parliament repeals it. Okay. Becomes valid if President assents it. Okay. It can be revived by simple majority. It's wrong. Is wide to extent of its inconsistency with fundamental rights. So these 3 statements are wrong, and we arrive at option D. So if you look at the synopsis, Article 13 makes any law inconsistent with fundamental rights. Why to the extent of its inconsistency? Because it does not wait of President's assent or parliamentary repealing or even being revived by simple majority. It will create automatic wideness to the extent of inconsistency. The other options invent the conditions that do not exist. Because here we apply doctrine of severability and doctrine of eclipse. If you don't know doctrine of severability and doctrine of eclipse, I think you should go through it once, because doctrine of eclipse says that as long as a law is violating a fundamental right, it shall be eclipsed, and when the fundamental rights, that particular fundamental rights is not into existence under the constitution, then the law will be having utmost effect. Doctrine of severability says that only a certain part of the act, let's consider if this is the act, and certain provisions are in void with the fundamental rights. They are in contrast with the fundamental rights. But this part is it will be good in terms of its application through fundamental rights. Then this part is considered to be legal or constitutional, whereas this is struck down or it is considered to be void. This is the basic concept of doctrine of civil liberty. Only the contrasting part is removed and the other part is made eligible and it is used to govern the country. Simple. Yes. Let's move on to question number 12. Consider the following statements about Attorney General. Attorney General, we all know, Article 76, appointed by the President. That's right. He must be qualified to be appointed a judge of a Supreme Court. That's right. He has a right to speak and take part in proceedings of both House and to vote. One thing we need to keep in mind is that he can definitely participate. He can discuss. But the thing he cannot do is voting, because only a member of parliament can vote. And how can you become a member? When people elect us through elections. So this is the case. So he cannot vote. This is option 3 is definitely wrong. These two are wrong. 1, 2 and 4 or 1 and 2. He holds office during the pleasure of the president. That's absolutely correct. So we arrive at option D. That's right. Let's go to question number 13. Consider the following statements about loss of Indian citizenship. Termination occurs automatically when a citizen voluntarily acquires the citizenship of another country. That's right. Naturalization is mode of losing a citizenship. No, it's actually the reverse of it. Naturalization is a method of gaining the citizenship or acquiring the citizenship of India. So this is wrong. Deprivation is a compulsory loss ordered by the government for fraud or disloyalty. That's right. Renunciation can be imposed by the government against the citizen's will. Renunciation means it's actually the removal of the citizenship. Renunciation means taking back. Renunciation is actually voluntary in our Indian conditions, so option 4 is wrong. So hence we arrive at option 1 and 3. That's right. Let's go to question number 14. Consider the following provisions. Election of the President. Distribution of legislative powers between Union and States. Representation of States in Parliament and fundamental rights under Part 3. Amendment of how many above requires ratification by at least half of the state legislatures in addition to special majority in Parliament. Basically it is also a question on amendments and the procedure related to it. Election of the President, as we know that it will affect the basic structure of the Constitution and the federal features as well. So it needs a ratification of states. Distribution of legislative power between Union and States comes under Schedule 7 and Article 246. So it definitely needs ratification. Representation of states in Parliament, Schedule 4. This also needs the ratification. And fundamental under Part 3, Constitution explicitly says that only Parliament has right to legislate on fundamental rights, and although these do not affect any kind of federal nature of Indian polity, so we don't need for it. You only need for 3. Let's move on to question number 15. Who among the following is eligible to be elected as President of India? 34-year-old citizen qualified to be a Lok Sabha member. Okay. 29 wrong. 24 wrong. 34 wrong. The minimum age is 34 years and he need to be qualified. He need to be qualified to be a member of Lok Sabha. So we arrive at option D. Let's go to question number 16. Which one of the following best describes the legal procedure of preamble today? It can be used to override a clear provision in the main body of Constitution. I don't think it can be used to override a clear provision. So it's wrong. It is merely a decorative statement. It's definitely wrong. It cannot be amended. No, that's wrong. It is a part of Constitution and can aid interpretation but does not enforce. Is not enforceable. I think it is one of the best statements in this given questions. That's right. Let's go to question number 17. Statement 1 says that Supreme Court upheld abrogation of Article 370, holding it to be a temporary provision. That's right. So, court held that Jammu and Kashmir retained an element of internal sovereignty even after its accession to India. No, the court didn't held any such kind of statements. So this will be option number 1. Let's go to question 18. Consider the following statements regarding judicial review. Okay. The power of judicial review is available to both Supreme Court and High Court. Yes, that's right, because both are court of record, and this will be both will be having the power to review judicially. Next, the second is the phrase judicial review is explicitly mentioned. No, it isn't explicitly mentioned. It has evolved through the judicial interpretations and all. So this is wrong. Judicial review extends to the laws placed in 9th schedule after 24th April 1973. This is the date when Keshwananda Bharti case judgment was heard in the court, and after this, in A.R. Coelho case, Supreme Court held that after this date, any law which is placed in 9th schedule shall be subjected to judicial review. That's right. Judicial review is a part of basic service law. So we come to the option 1, 3, and 4. Option B. That's right. Let's move on to question number 19. Arrange the following parts of Constitution in an order in which they appear. This is the easiest question I have ever seen in my life. It's 2, 3, 1, and 4. 2, 3, 1, and 4. Let's move on to question number 20. Statement 1 says that India follows the system of single citizenship. That's right. There is no separate citizenship for states or its residents. Yeah, because we read India as unlike US, where it has a separate for national citizenship as well as a state or the federational citizenship, which is a dual citizenship. But India only has single citizenship because we are union of states, not federation, as unlike USA. So both statements are right. It should be option 1. Question number 21. Consider the following statements regarding money bill. Article 110. It can be included only in Lok Sabha. That's right. It can be introduced only on recommendation of President. Even that is correct. The Rajya Sabha can amend or reject it. No, basically it cannot amend or reject it. Only it can make the recommendations. That way under 14 days. If it takes more than 14 days, it is deemed to be passed by Rajya Sabha. Then the Speaker of Lok Sabha certifies whether a bill is money bill. That's right, only 3. Question 22. The Indian Constitution defines India as a federation. No, because it defines India as union of states. It's wrong. Then the residuary powers of legislature are vested in states as United States of America. No. The residuary powers are vested with Parliament. So we are at option D. Question number 23. Consider the following statements about Constitutional Assembly. It was constituted under Cabinet Mission Plan of 1946. That's right. Its members are directly elected on the basis of universal adult frontage. No, some were nominated as well. The objectives resolution was moved by Dr. B.R. Ambedkar. No, it was moved by Jawaharlal Nehru. So option 3 is wrong. It also served as provisional parliament after 1947. Yes, that's right, because our general elections were held in 1952 and 53. Till then, it was our provisional parliament. So we are at option number 1. Question number 24. Consider the following statements about Speaker of Lok Sabha. Okay, Speaker. The Speaker decides whether a bill is money bill. That's right. A Speaker has a casting vote in case of tie. Correct. The Speaker continues in office even after dissolution of Lok Sabha until immediately before the first meeting of next Lok Sabha. Yes, it is explicitly mentioned in Constitution. The Speaker is removed by special majority of Lok Sabha. No, it usually requires a simple majority of people present and voting. This is wrong, so we arrive at option A. 1, 2, and 3. Let's go to question number 25. A right to be informed. Consider the following safeguards under Article 22, protection against arrest and detention. Right to be informed on the grounds of arrest applies to preventive detention. No, this is the one which will not apply to preventive detention. It will apply to punitive detention. Right to consult a legal practitioner of choice applies to ordinary or punitive arrest. That's correct. Production before a magistrate within 24 hours applies to ordinary arrest. That's also correct. The right to be informed on grounds of detention applies to preventive detention. Now this is right, because the grounds of arrest need not to be given to preventive detention person, whereas the grounds of detention should be given. So option A is right. That's right. Let's move on to question number 26. The Indian Constitution is neither wholly rigid nor wholly flexible, as because you can see both kind of procedures for amendment, whereas simple majority, complex majority, where we have special majority of two kinds. So by this we can say it is not fully rigid or fully flexible. It can amend by three methods: simple majority, special majority, and special majority together with ratification of states. I think both are right here. That's correct. Let's move on to question number 27. Statement 1 says that a money bill can be introduced in either of the house of the parliament. That's wrong. The Speaker of the Lok Sabha certifies whether it is a money bill, and that's right. So we'll have option D. It's question 27. So let's move on to question number 28. Which one of the following best describes a money bill and the Constitution of India? I think I have seen a similar question in UPSC prelims. Even some of the questions in KPSC are somewhat related to UPSC, or even closely related to UPSC PYQ. So it's better for us if we solve some UPSC PYQs also. Okay, now let's move on to question number 28. Which of the following best describes a money bill under Constitution of India? A bill that contains only provisions dealing with matters specified in Article 110, sub clause 1. Okay, it's correct. Any bill that involves expenditure? No, that's wrong. Any bill introduced by finance? No. A bill certified as by the chairman of Rajya Sabha? No, it's actually Lok Sabha. Question number 29. Which one of the following would be a violation of Article 24? Basically, it is abolition of child labor. 16-year-old working in hazardous mine. Okay. 15-year-old helping a family shop. 13-year-old attending school. No. 13-year-old working in hazardous factory. I think that's right, because the age was reduced to 14 years. Who can work in non-hazardous? Below this they shouldn't work, above this they can work. Question number 30. Consider the following statements about the right to freedom of religion. Okay, right to freedom of religion, Article 25 to 28. It's available to all persons and not only to citizens. That's correct. The state may regulate secular activities associated with religious practice. Yes. The right to propagate religion includes the right to convert. No, this it is wrong. The state may make laws for social welfare and reform of religious institutions. That's absolutely correct. So we are at option B. So this was the 30th question. We are still left with 20 questions. Thank you for your patience till here. I will be doing, or we will be doing, these 20 questions tomorrow. Definitely. I think the video will become too long. Already it has reached about 30 minutes. So it's better if we do the remaining 20 questions tomorrow. And definitely I will be uploading it. If you have any suggestions for me, or if you want me to do UPSC prelims PYQ on polity section, let me know in the comments. And thank you for your patience. See you tomorrow. Jai Hind.